Kia ora koutou. You find me here on the 7th floor of the Richardson building on Saturday the 5th of August. I am here to answer your many questions. I'm obviously very sorry that I wasn't able to attend class on Thursday. Unfortunately, the flu that was pretty much with me on Wednesday took a hold of me in an even greater way on Thursday, and I was unfortunately unable to make it. But nevertheless, you had many good questions for me, and I wanted to give you an opportunity to hear the answers. I have lots of piles of paper in front of me, and I have a mug of hot tea, and I will give this an hour or however long I can be bothered asking your very, very good or slash very personal and in some cases slightly homophobic questions. Okay, the way I want to do this is I have 3 piles of relevant, interesting questions about the course that I'll get through, but obviously those are a little bit boring, and so we can intersperse those with some of the more interesting questions that you've asked about stuff that's got no relevance whatsoever to the course. Let's begin though with a couple of exam prep questions. This one is, how many cases should we cite? Are general principles relevant? I.e., this is a problem though, if it's an exam question. If I can't read your handwriting, that's the first thing that you should know. Make sure that you have clear handwriting. It's really important. If that requires you to just go a little bit more slowly when you write, then that's what you need to do, because I couldn't read this. General principles are relevant, so how much do we focus on this compared to legislation? I'll put the question up there just so you can see that I'm not just making them up. How many cases should we cite? Look, I understand this question comes up a lot. Namely, that judicial review is something that appears to use cases differently than other areas of law that you deal with in second year. Think of it this way. We have cases in judicial review that establish principles, and those principles are the ones that you need to use when trying to navigate any particular problem that you might have in administrative law. And so the cases that we've used won't be used in the same way as, say, you used them in first year, where there are easily direct analogies that you can make to the cases that you've learned. Instead, they'll be used to establish general principles that you can then apply to the particular facts in the particular context at hand. So, for example, if you're dealing with a case that involves the right to natural justice, for example, Daganayazi, for example, stands as a principle of when natural justice obligations can be read into a piece of legislation and when natural justice obligations will arise from the context. But if the case at hand has nothing to do with immigration, it's clearly not going to be directly analogous to that particular case. Nevertheless, it's going to stand for that principle about reading a natural justice. Don't simply use the cases because you feel like you have to. Use them as a way of signaling a particular principle. And if you don't really cite the cases, for example, but you nevertheless get to the right answer, that's what we're looking for, right? An understanding of how judicial review works rather than simply memory recall, okay? Second question I got about purely exam-based issues. Structure. How to structure a question for the exam. Right, so that's not a question, but I get what you're saying, I think. How to structure a question for the exam. There's no right way, unfortunately. As I've mentioned, you can take a cookie cutter approach, and your old notes that you've got from old friends and old colleagues and that sort of thing will have a particular structure that they've used, for example. But the best way I feel that you need to structure a question and an answer to a question specifically is to go according to the circumstances. Make sure that it's reflecting exactly what the contextual circumstances are at hand, and answer the question accordingly. It's not going to be something that you can simply apply a formula or a particular approach to and get away with it every time. Instead, if you respond to exactly what the contentious issues are, if you identify the particular issues and hone in on them, that's always going to be a far more productive approach and hopefully a profitable approach compared to simply applying a set structural template in terms of answering the question. Now that I've freaked you all out with that sort of exam feedback, I guess, or approach, we can answer some of your inappropriate questions. What is the solution to the war on drugs? Should cannabis be legalized? Probably as a start. It doesn't seem to be working, this war on drugs, does it? And the prohibition of cannabis and the fact that you have one plant in your house and you get maximum prison sentences 7 years potentially seems to be a bit draconian and establish an effective black market for much more serious drugs, which is not what you want. When was your last haircut? I love this question, by the way, because it says, when was your last haircut? And then crosses out the question, P.S., please briefly go over the variable intensity of review requirements. So I'm glad that you crossed out the relevant question. When was your last haircut? 2.5 weeks ago. The day of the moot. The dean made fun of me a lot. Can I have a blaze with you? If I think what you think that you're thinking, no. Sorry. How was Wellington? Don't you just love the bucket fountain? Wellington was okay. It's when I got sick though, and so that wasn't very good. I don't really like the bucket fountain. I've got this uncanny ability to get wet by it every single time I pass. It splashes over. It doesn't seem a very efficient approach. Oh, and what's your favourite cafe in Dunedin? I think that's a difficult question. I obviously always go to the dispensary, but that's usually just for proximity and convenience reasons. And I would say RDC, Rez de Chaussée on George Street is probably my favourite. If you don't know it, don't look it up because I don't want to see you there. Okay, so now I have two piles of questions, one about judicial review, one about the Bill of Rights Act. I'll deal with the judicial review questions because if you really wanted to know about those, you are probably only watching this video for those, and you may not necessarily care about the Bill of Rights questions. I get that completely. What was the outcome in bulk gas? Can we not have privative clauses? That would have been a tenable conclusion to take from bulk gas. That case, if you can remember, was all about whether or not there was an error of law, but more importantly, there was a provision in the Commerce Act at the time that said that it wasn't able to be challenged in a court of law, and the Court of Appeal in that case held that that wouldn't have prevented them from successfully reviewing it if there was actually a ground made out, which there wasn't. The way they got around privative clauses in that situation is simply saying that Parliament wouldn't have intended a decision maker to have acted outside of their power and for that not to be reviewable. And then for the privative clause would only apply when they were acting within their power, but that essentially made it useless. For a long time, that approach tended to reduce the number of privative clauses in legislation. There were a lot before bulk gas, and after that they reduced. But recently there have been a resurgence in privative clauses, but that's a little bit advanced. And by the way, if you really like judicial review and you like these issues, then you can always take administrative law with me once you get out of second year. We look at these sorts of questions. Should we go through all the heads of the review in the test, or just focus on the ones that apply? Just the ones that apply. Why would you waste time on the ones that don't? It just looks like you don't know what's going on in that case. There are lots and lots of questions like this about, do I need to deal with everything? You just need to deal with the stuff that actually matters. And that's what's going to show me and the other markers that you know what's going on. Would an exam ever ask us about the other grounds of review, or is that more just general knowledge of the development of the grounds of judicial review? Whoops. Look, never say never, but they are other for a reason, namely that they don't often get used, and therefore you've got to wonder in what situation will they be really relevant, and the question that you've got, will more orthodox grounds of review be the way to go? They are certainly part of the story of the development of judicial review in New Zealand, so it's important to know about them. And as I say, I wouldn't forget about them or think that you don't need to know about them at all. But at the same time, I'll go back to that original answer, which is they are going to only be other grounds of review for a reason, which means that they aren't particularly commonly found. Do we need to incorporate remedies / what remedies they will get if they challenge and win if we are not specifically asked? It's going to be a relevant issue because it will show that you understand that the remedial jurisdiction in judicial review is discretionary and not a fait accompli, and therefore requires a bit of nous to understand what you're going to want and when you're wanting to get it and how you're going to get it and whether or not the court's going to give it to you. It's more than anything else a bit of housekeeping at the end of a question usually, but if there is sort of conduct from the applicant, for example, that might really provide a barrier to them getting the review, the remedy that they want at the end of a successful review, then yeah, that's going to be relevant. Okay, couple more fun questions. Marcelo with 2 L's. I love it when people put 2 L's in my name, by the way. Absolutely love it. Where do you buy your clothes? Not from one store, but Rembrandt on George Street is pretty good. That probably explains why people think I dress like a young Nat, but it's nice to support local. Rank our second year law subjects in terms of how hard each exam is. That changes every year, presumably. So I don't know what the rank is. Property always seems impossible to me, same as contract, but that's probably because I'm not a private lawyer, right? So I think depending upon what subjects you like, it depends a whole lot upon that. Right, back to judicial review. When reading in natural justice obligations, how do you tell if the Act has gaps for the court to fill? It seems like a fine line. What are the obvious signs that there are gaps for the court to read in natural justice obligations? See, this is what I was referring to at the start with the case of Dakananiazi providing a set of principles. And you can see in that case exactly what was going on that would have allowed the court to read in those natural justice obligations. 2 sides of the story. First, her interests and her rights were being so specifically and uniquely affected that justified, right, the creation of natural justice obligations. She had a right to see an adverse report in that situation. Why? Because the impact upon her was going to be so significant. Now, that's only possible, however, if you can read in those obligations into the Act. And the Act didn't speak about any sort of natural justice obligations. It referred to an appeal by the minister, and it gave some time frames and that sort of thing, which gave pointers. It didn't displace any obligations being read in, and it certainly didn't provide for them either. That's what we would call a gap. All we talk about when we say gaps is basically whether or not it's possible for the court to do so, because if they can, they will. It's only in situations like Creed and Z where basically any sort of common law intervention is being displaced by the code that it creates that we have a problem. Please explain intensity of review again. For example, low intensity equals high standard of reasonableness. Does that mean with a low intensity, the judge requires a lot for something to be considered reasonable? Shouldn't it be vice versa? And the same sort of question, can you Please explain the low intensity / high state of unreasonableness, vice versa bit of judicial review. Oh, I'm not very good with cameras. Okay. The best way to think about intensity is to think about expertise and to think about who has got the most expertise to decide a particular matter. Because if it is the court, then the court is not going to give so much deference to the original decision maker. That means that they're going to apply a very high standard of intensity. They're going to look at the decision really closely because they have more expertise. Similarly, when the decision maker has more expertise in a particular matter than the court, then the court's going to defer to the decision maker and take a very low intensity sort of approach and not look at the decision particularly closely because it doesn't have the expertise to do so. How you determine who has more expertise than the other? It's multifactorial. And so you've got to think about who the decision maker is. Are they democratically elected, or are they just some sort of functionary in a back office? Are they making a decision involving human rights? Are they making a decision full of high policy, for example? There's that matrix that I provided in the handout that guides that question. That will determine the intensity of review, but also determine who has more expertise than the other, and therefore which body is deferring to whom, right? The tricky part comes because you've got this weird situation of a low intensity of review, meaning a high standard of reasonableness. And think of it this way, it's from the applicant's perspective, right? So for the applicant to show that a decision maker has become or has acted unreasonably when it's low intensity, it means that the court is deferring to the original decision maker, which means it's very hard for the applicant to prove that that decision maker acted unreasonably because the court is deferring to them, right? Because there's an acknowledgement that they had the expertise to make the decision, and vice versa. When the court is not deferring to the original decision maker, when there is a high intensity of review, when the court decides that it's probably the best body to make the decision or supervise the outcome and determine its reasonableness, think of cases like Watson, for example, then the applicant, Watson, doesn't have to do much, simply show that there is a logical flaw in the decision-making process to show that it's unreasonable. And that means that in a high intensity of review, there is a low standard of reasonableness. It's confusing, I know, but as long as you understand the theory, it's easier to work it out that way rather than just trying to remember the low-high combinations. What's the actual test for unreasonableness or irrationality? This is sort of the similar sort of question. We know that Wednesbury unreasonableness, and sort of codified by Woolworths, is an idea of something outrageous and its defiance of logic, octopus. We also know from cases like Wolf or Watson that a low standard of unreasonableness, something that's much less than Woolworths or Wednesbury, would be similar to a lack of logical sense, a gap in the logical progression of the decision-making process. That's what was going on in Watson. And so that would be what we would say are the different tests for unreasonableness or irrationality. Okay. Some other questions. A trolley is traveling along a junction towards a person who is tied to the tracks. You can save their life if you pull a conveniently placed lever which will switch the tracks and cause the trolley to collide with a passing sheep. Do you switch the tracks? Depends if I like the person. I like sheep a whole lot. Who are you married to? None of your business? Oh my goodness. Saw you at Hutong a couple of weeks ago. What is your favourite meal? I can't go past the peanut satay. I highly recommend. No questions. Your lecturing is fab. Okay, fantastic. There was a question though. The peanut satay is very tasty. And what is your least favourite legal decision and why? From our course, I would suggest AMM and KJO doesn't make a lot of sense to me. Don't get me wrong, I love the outcome. I think it was ridiculous not to sort of allow those who weren't in a married heterosexual relationship to be the only ones who could adopt. But the reasoning is poor. Or at least getting from the outcome and then extrapolating, and then really having to justify why it's not extending logically to other types of couples seems to be a fast move. So that would be a decision that I don't think necessarily makes a lot of sense and maybe undermines the case for that sort of Section 6 approach to the New Zealand Bill of Rights Act. But, you know, it's not a bad outcome, I guess. I'll have to think of that while I'm sort of going through these other questions and see if I can come up with a worst case. Can you go over intensity? Just a quick recap, already done that. Your name is, so this is just another, okay. So your name is exotic. Explain what does the B stand for? Hair equals goals. Okay. So we've already gone through intensity. I'm not going to tell you what my middle name is, and congratulations, it's not that difficult to get this sort of here. What is the most important case to know for judicial review? No right answer there, unfortunately. All different cases, right, establish all sorts of different principles in judicial review. There's not one core sort of fountainhead of case law. There's no Donoghue and Stevenson or Rylands and Fletcher here, because that's not how judicial review works. It's an inherent jurisdiction the court has always had. It's not something that it had to create out of nothing. As a result, lots of different cases will be relevant for different purposes. What is judicial review? Judicial supervision over administrative decision making. As simple as that, right? That's what you got to think of what judicial review is to understand what it is, and you usually can sort of work it from first principles as a result. How do you distinguish between mandatory considerations and procedural impropriety? They're different areas is the first thing to know. That's going to be the easiest way to distinguish it. Mandatory considerations are all about what the decision maker has to do before he or she can make the decision. And so, if there is a set of mandatory considerations that the decision maker doesn't consider, then the decision, whatever it is invalid because they didn't follow the preconditions to making the decision beforehand. Procedural impropriety, on the other hand, is all about the impact upon the person to whom the decision relates. And more often than not, it's going to be implied common law obligations if the statute doesn't speak about procedural impropriety that we're talking about. So if you have to distinguish them in a theoretical sense, I guess you say that ex ante, before the decision gets made, that's what mandatory considerations are all about. But it's only after the decision gets made and then the person seeks judicial review that you can determine whether or not there has been procedural impropriety or not, because often it's going to be a contextual assessment. Fully explain, okay? Delegated legislation. What is it and its relevance to judicial review? Well, we've got a limited time, so I don't know if I'll be able to fully explain it. Delegated legislation is simply legislation that isn't primary legislation. It's legislation that has been made by the executive branch of government, delegated that power by Parliament, right? So Parliament delegates a certain amount of legislative power through an empowering provision to the executive. And then that executive makes that legislation. It could be anything like an order in council, it could be regulations, it could be all sorts of things. But the key point is it's the executive doing it under delegated authority by Parliament. And because that's the case, because it's the executive doing it, it is susceptible to judicial review like any other decision that the executive branch of government makes. And that's the relationship to judicial review. Because it's the executive doing it, it is also susceptible to judicial review in the same way as other decisions of executive government are. What does Christchurch Great Buildings Trust and CPT stand for? This case is very straightforward. Simply that a decision to not reconstruct the Christchurch Cathedral didn't impact directly on the CPT Trust, on the Christchurch Great Buildings Trust. The CPT Trust owned the cathedral. And as a result, there was a question as to whether or not they could seek review of that decision. If they weren't part of the church, if they weren't being directly affected by it, could they have standing? And the court held in that case, Justice Chisholm said, that essentially there is a relaxed approach to standing on issues of public interest such as this. And so it's clear when there is a bigger impact on the public, when there is a widespread sort of impact, then it's going to be easier to prove standing. But query whether or not standing requirements would still apply in situations, for example, that don't involve public interest. I think there are other questions like this, so we can return to that. Can you give an example of a situation where the court would be forced to prioritize one constitutional principle over another in judicial review? I can. Bulk gas, right? Privative clause, if you take it literally and you prioritize parliamentary supremacy, then you read it literally and you say that my hands are tied and I can't engage in judicial review. Or if you pick rule of law instead of parliamentary supremacy, you say, notwithstanding Parliament saying this, our constitutional role as a court is to engage in judicial review, and as a result, we're nevertheless going to proceed with judicial review, notwithstanding the fact that there's a privative clause telling us not to. Okay. Did you do Miss Natural Justice at law camp? I didn't go to law camp, so no, I did not. But my good friend Jessie did, and hasn't lived it down since. Did you know that you look like a carbon copy of Milo from that Atlantis Disney movie? Also, Waffle from Chicken Run. If I can manage to multitask, I will check out who Milo from Atlantis is. And I can't multitask because I am not able to speak clearly. And we'll see whether or not Milo Thatch. Oh, wow. Thanks. He's really attractive for, a cartoon. I guess I'll take that as a compliment. And just as I was feeling good about myself, I get this. If your name is Marcelo, why are you white? Why are you racist? How old are you? 32. Dear Marcelo, 2 L's again. Nice. Based on your haircut, you clearly have joined the alt-right movement. As such, are you stoked that Andrew Little is stepping down as Labour leader, or is that problematic? Okay. I don't even know what to say about that. I think the premise is wrong. I haven't joined the alt-right movement. Sorry to disappoint if that was indeed a disappointment. I actually might need to get through a little bit more of those personal questions. They are mounting, but we'll get through some more JR questions now. What are the subtopics that come under each major ground of review? Illegality, e.g., illegality, procedural and propriety. Look, you can look that up yourself. We've got the course outline that sort of provides a sort of clear outline of what's going on there. Illegality are things like the instructions, right? The idea of what the decision maker was supposed to do before he or she could make the decision. Procedural impropriety is all about the fairness of the decision on the person that it affects. And of course, unreasonableness is looking at the outcome of the decision. But that's easily findable. And if you are looking for sort of further guidance on this sort of stuff, the sort of specifics and the different kind of actual nomenclature, that sort of stuff, then Joseph's book's on reserve in the library and would provide a clear catalogue of all the different grounds that there are, if it's not already clear from your notes. Whoa, this is a doozy. Because substantive unfairness and proportionality are no longer in common use, do we have to mention them in exams and tests? I've already answered this question earlier. If they are particularly relevant, it seems, then go for it. But you're right insofar as that they are marginal and not often used. So take that as you will. 2. Once you've taken the mandatory considerations into account, can you have your own extra purposes as long as they don't contradict the Act? Unison seems to allow this as long as it's being used to pursue the statutory purpose and the statutory purpose wasn't compromised. But gosh, page 79 of the course materials, right-hand side, seems to suggest that it might exclude considerations which aren't expressly or impliedly bound to consider by the Act. This is actually a really controversial area of administrative law, and not one that you need to worry about. It's amazing that you've struck upon it. But the general point is you're right. Unison seems to suggest that you can pursue additional purposes so long as they don't contradict the Act. Now, that is still, as I say, a matter of controversy and query what kind of additional purpose would be so different that it wasn't achieving the original purpose anyway, but not undermining it as well. That's a difficult theoretical step to take, but don't worry too much about that question. And on scale 1 to 10, how similar do you think that you look to Milo Thatch? Right, this is this guy again. Well, he's a lot more chiseled than I am. So I'd say, I think the glasses are pretty much the only thing that's similar, actually. 5. Do we even mention non-contentious issues? Just to show that we know what they are. I get it, that you want to look like you're smart, that you know everything, that you've studied really hard, but the way that you look smart, to me, in judicial review is by being precise, surgical, and targeted. Understanding that some things are going to be relevant, and hardly ever will there be a situation where every single ground of review is going to be relevant. And instead, by showing that you know all the different grounds of review is fantastic, but only in the same way as writing down every letter of the alphabet shows me that you know all the letters in the alphabet as well. Congratulations, not going to be a marked down sort of situation, but also not necessarily going to be deeply impressive to me. Knowing exactly what grounds of review are going to be relevant and why, that's going to be far more impressive. And 2 similar questions, I guess. In a judicial review exam question, do we have to bring up the issue of standing? It's non-contentious. It is. Non-contentious it is. Yoda now? But for extra marks, question mark? And do we still have to talk about standing in an opinion, or is it irrelevant now? It's not irrelevant because sort of as I alluded to in an earlier question, there are going to be situations in which it's questionable why the applicant has standing to bring a case. But the general point is that when there are issues of public interest involved, no one's going to bring them. There is a line of cases, starting with Finnegan, sort of clearly followed on by that Christchurch Cathedral case, that standing requirements are going to be relaxed. But you can imagine when it's an individual decision, right? Why some random other person would have the ability to bring standing would be in question. Bring review would be in question. So it's not completely going to be irrelevant, but if it is, and it's non-contentious, I go back to the previous answer I gave, why are you mentioning it then? It's more about an efficiency sort of calculus, right? You can spend all your time covering everything and basically do a little bit of every ground and you'll be fine. But a far more productive and far more profitable approach would be to focus on those rich seams of controversy that you can really get some good marks in because you can show exactly what you know and how it works and why it's relevant. Okay. Oh dear. How much weed do you smoke? Answer truthfully. Okay. But then I like this. Quote, I will read them out in all their entirety. As if that makes me as if that means I have to answer this question truthfully, or even I have to sort of acknowledge it at all. Okay, a lot. Huge amounts. An Olympic-size swimming pool. Actually, I was Hanson. I carry around 2 kilos on a daily basis. Cool. What was your grade in public law? What was your worst grade in second year? Jesus. My grade in public law was 79. I'm surprised I remember that. And my worst grade by far was contract. Oh God. No, I'm sorry. You can't. I didn't realize that's what this haircut was. I'm not going to read that one out. If you could be any animal, what would you be and why? That's a good question. I don't know. It's difficult to work out what kind of level of consciousness or awareness any other animal would have, so I don't want to sort of presume, but that's a boring answer to the question, isn't it? So I'd say like awesome hawk or something like that. That would be fun, I guess. Not very vegan though. How fresh of law school are you? Because you look 12. Thanks. I graduated in 2008. So, yeah. Final year was 10 years ago. There we go. Will any bit of Part 4 show up in the test? If you read the instructions on the test, and I encourage you to do so, it's really clear that no, Part 4 is not going to be in the test. Please read those instructions. In judicial review, how do you decide which remedy to use? Then do you have to justify why you used it? Think of what the remedies do and think of what your client wants. That's as simple as that. Do they want the decision made again? Do they want the decision never to have been made? That's what's going to make the difference, is do you understand what the remedies do and why your client is seeking judicial review in the first place. That will be the justification. Can you quickly go over Padfield? My notes on it make no sense. I mentioned Padfield in class extremely quickly because it is a complicated case. All you need to know is what it is relied upon in unison. Namely, that there is an idea that you can't have an unfettered discretion as an administrative decision maker. That there is always going to be hard limits on what you can and can't do, even if that discretion is in unqualified terms. And so when you're acting for an improper purpose, notwithstanding that you're acting within the letter of the discretionary law, you will still be found to be outside of that power because Parliament wouldn't have intended you to use the power for that particular purpose. Padfield is simply the establishing case to establish that principle. Unison is essentially a redux of that. Can judges be subject to JR? Can court decisions be subject to JR? That's a really interesting question. District court and below, or of a similar size, so district court, family court, environment court, that sort of thing, yes, because they are statutory courts. High court and above, no. Not because the Court of Appeal and the Supreme Court aren't statutory courts, but because the High Court isn't. And the Court of Appeal and the Supreme Court are deemed to be the same status as High Court judges for constitutional weird reasons. And the point being is that the High Court can't review itself or anyone higher than that. So High Court decisions can't be judicially reviewed, but District Court decisions can and often are. Right. Best tips for the test next week? Question mark? Maybe? Don't panic. Don't stress out. I'm not trying to trick you. I've set a test that I think is fair, that will test those who want to be tested, if that makes sense. My best tips is to not stress out, take a deep breath, read it really thoroughly. Less is more. Not only will your marker be happy if you've written less, believe me, but you'll also get a greater appreciation for what's going on and the context and that sort of thing if you slow down, take some time to really understand what's going on rather than just going hell for leather out of the gates and starting writing from the get-go. If you slow down, understand the statutory context, answer the questions as they are set, right? Not ones that you want to answer, you will be absolutely fine. What will the test question be? On judicial review. Here we go. Oh, right. I scanned these questions, just scanned them very quickly. This one was a doozy. In the outline, there are a few cases that we didn't really go through, but there are some statements from the cases in there. Can we still use them without being told we are using old notes? Look, oh gosh. Don't use old notes. I told you not to. The course has changed from last year, okay? If you're using old notes, you're only doing yourself a disservice. They may feel like they are a Bible, but the thing is that they weren't written for you. They were written for the person who wrote them. And that means they were written according to the weird mental makeup that they had and not yours. It's really critical that you get out of this tradition of using old notes or thinking that someone has the answer and the key to unlocking judicial review or any aspect of second year. The best thing you can do is to trust yourself. And if you do need some authoritative source, don't go by someone's old notes. Go to a textbook. Go to the commentary we've got in the library. So I know that didn't answer the question, but yeah, you can use any case you want if it's relevant. But you don't need to, and you certainly shouldn't be using old notes. You're really putting yourself at risk by doing that. How much do you weigh? Jesus. Okay, I lost a lot of weight over the last week through this wonderful sickness, so about 70 kilos at the moment. Who marks the final exam? It'll probably be Andrew and I, maybe Nick. I don't know. She's on research leave at the moment, but not the tutors. That's the pink point. But I'll certainly be there. What did you say to piss off Jeffrey Palmer? That they shouldn't have put a bunch of controversial reforms in their constitution if they wanted it to be taken seriously, which was not taken well, unfortunately. Right, how old are you? 32, still 32. Okay, we have 3 more questions of judicial review left. If you meet the test for predetermination, does that mean you do or do not have a closed mind? Predetermination is the sense that you do have a closed mind, right? So if you are predetermined, it means that you have closed your mind to any other outcome. And as a result, you aren't acting fairly by basically not considering other alternative options. As a result, if you meet the test, if you are predetermined, yes, you have a closed mind. It's essentially on that spectrum of bias, right? That's where we would differentiate someone, say, as Justice Wilson. He didn't need to be predetermined before being found biased, but in a situation such as a politician, that's where they would need to be before predetermination or that idea of bias would apply. Do the innominate and proportionality grounds of review still apply, or do we use unreasonableness? I think I've explained it a couple of times now. Unreasonableness is often going to be sufficient to take the ground of what would usually be taken by innominate proportionality. Remember, they were trying to fill the gap that unreasonableness wasn't filling at the time, but now it does, so query their relevance. Excuse me. What was your worst grade in second year law contract? We've done this. What's your favourite banger? I think banger means bad song, right? Okay, so let's just go with that. Otherwise, I don't even want to know what that question is asking. I would say Total Eclipse of the Heart by Bonnie Tyler. What's your favorite law meme? Oh man, these questions are making me feel old. Oh golly, I don't know. I think I explained one where I saw on this Facebook page that someone showed me constitutional memes for something. And there's someone saying that common law, some rights sort of run so deep that not even Parliament could shake them, and whispering in the ear and it's standing up on your arms. I enjoyed that. I giggled. Okay, the final... Sorry, that was poorly answered. The final judicial review question. Can you please quickly sum up legitimate expectations and when they are justified? 2 ways legitimate expectations will arise, okay? 1, a decision maker makes a promise to you. I will consult you before I make this decision. And as a result, you get an expectation that they're going to consult you before they make the decision. And if they break that promise, then they have broken your expectation and they have acted unfairly. Or if every single time that they have made this decision they've consulted you, they don't need to promise, you can expect that it's going to continue in the future, right? And if that has happened, say, 20 times in the past, but doesn't happen in the time that you're complaining about, then once again, your expectation has been broken. It's all about holding executive government to the promises of procedure that they have agreed to follow. It can't counteract anything that goes against it in the Act. That defeats the expectation. Nor can it be to a particular substantive benefit. That's what the case of GXL was all about. But essentially, when someone promises a particular process and they don't follow through with it, then that's what we're talking about when we refer to legitimate expectations. Those are all the judicial review questions. Okay. Oh my God. How old are you? 32. Are you married? Yes. Where are you from? Or where is your name from? Okay, yeah. So you acknowledge, right, that when you say where are you from is sort of just assuming that despite all of my appearances, right, my name means that I must be foreign, which is kind of annoying. Nevertheless, my dad is from Argentina. That's why I've got my weird name. Can we have a Wear Stripes Day? Okay, that sounds like a great idea. This is the sort of thing that I hope that you put in your feedback for on the evaluation form, because it would have been... We can have like a stripe amnesty day. That sounds like a good idea. You appear to wear the same trousers every day. Do you A, own many pairs that are the same, B, have a very diligent laundry schedule, or C, just rock it? I.e. the student who's wanting to save time, money, effort by not washing frequently style. I'm not judging. Both A and B. I have very many pairs of beige trousers, and I wash them very often. Who is your biggest role model and why? That's a good question. I honestly don't really know. Yeah, I hate to say this, but Professor Andrew Geddes is a good role model to have. You'll have him next week, and then you'll question my life choices and judgment potentially. What is harder to catch the faster you run? I don't know. I don't know. I'm sorry. Does it make me look stupid? Potentially. What song did you dance to for Miss Natural Justice at Law Camp? Didn't. Sorry. Apologies. Can you judicial review D's nuts? Clever. But no, because that doesn't sound like a decision, and probably not within the Judicial Review Procedure Act jurisdiction or any other common law jurisdiction, so joke's on you. Because we have a test on JR, will JR be in the end of year exam? I honestly don't know the answer to that question. We will tell you what is going to be covered in the exam closer to the time, but we haven't actually written it yet, so we don't want to make it too clear. I just can't speak to it. How old are you? 32. And how old is your bestie Mark? Well, he's not my bestie, unfortunately. That's got someone else's name on it. I think he's in his mid-60s. Nice haircut. Thanks. Okay, so what are we at? Oh man, it's 50 minutes already. Gosh, you guys must be bored. I'm exhausted, but we can persevere. Won't take too long. We've got some more Bill of Rights questions, I think, which are harder to answer, but there aren't too many of them. Is there a moral or ethical statement that underpins what breaches of the New Zealand Bill of Rights Act get heard by courts, or is it financial or power dynamic? Those that have got the money or power to get the case heard. If so, what power or money does Taylor have? Well, I think Taylor, that's a good question. It's not on a money basis. It takes a lot of money to sometimes bring these cases, sure, but at the same time, if you've got a will, you've got a way, and you'll find pro bono lawyers, that sort of thing, to help you out with it. It's the merits. It's always going to be the merits of which cases get heard or not. That said, the better legal team that you've got, the better chance that you'll get it through the procedural hoops it needs to get through. So there is a correlation between access to justice and money. But Taylor, for example, just really strong will and some good supporters outside of prison that helped him along his way. Should New Zealand have an entrenched constitution? Why or why not? We already have parts of our constitution entrenched. I query the value of it, to be honest. This is the argument I made in front of Jeffrey Palmer. Query whether or not you'd ever want to repeal, or what politician would repeal the Constitution in 1986 or the Bill of Rights Act, notwithstanding the fact that they aren't entrenched. And as a result, I wonder whether or not they've already got quasi-constitutional status. That said, what's the harm in doing it, I guess? The answer to that is that if you want to amend it, and sometimes it's justifiable to amend some things, you want to have an ability to do that, and it's dangerous to really lock yourself in. So I would say that it's not as key as it is often argued to be. Is there any way to have an entrenched Bill of Rights without politicized judges? I think you mean Supreme Bill of Rights, because I don't think the entrenchment of the Bill of Rights Act politicizes the judges. It's the supremacy of the Bill of Rights Act that politicizes judges, because it forces these line calls on moral decisions and the nature of rights to be decided by courts rather than politicians, who would normally be the body that would decide those questions. And as a result, I tend to think and subscribe to the view that does have a political effect on the judiciary. The Taylor case has just made it to the Court of Appeal. While Parliament remains supreme and does not have to change legislation, how does this change the nature of the New Zealand Constitution? Really nice drawing. I'm glad my lecture was that interesting that you had time to do that. Also, similarly, is Taylor still in jail? Answering the last question first, yes, he's still in jail. He's going to be there for a long time. He did a lot of bad things. And interesting, I didn't actually explain this on Wednesday, so it's good to have the opportunity to do so now. Parliament did nothing in response to that judgment by Justice Heath, nor the Court of Appeal's affirmation of that. So the declaration of incompatibility was as useless as the radio person I was talking to expected it would be. No response from Parliament, no response from the government, and that really was problematic. We all expected, actually, us constitutional theorists or whatever, I guess, Bill of Rights academics, that there would have been at least some acknowledgement or response, but the lack of any response was, I think, a dangerous precedent. You'd expect some sort of response from the government to that. Maybe once it gets to the Supreme Court, then we will find, and it goes that way again and confirms the Court of Appeal's judgment, hopefully, that you would find a similar sort of outcome, but who knows. Is Parliament really super supreme? Yeah, in theory, but we know that, say, the Bill of Rights Act has the ability to chip away at that to a certain extent. And as you'll learn with Andrew, you've got to determine what you mean by supreme. There is these ideas of binding future parliaments, for example. There are limits to absolute supremacy, of course. Okay, only a few serious questions left, but still a lot of relevant questions. Why the haircut? The hairdresser said it would look cool. I made a mistake. Oh, right. Hi, Marcelo. Are you aware the fact that a plant-based diet lacks EPA and DHA, which are the long-chain fatty acids found in seafood and really not a lot in kelp, that are fundamental to eyesight development and brain development? Okay, that's already a bit too far, but it gets better. And if you are aware of this, will this mean Marcelo Jr. is going to also be on a plant-based diet? Use white tape to get the errors out, which is very assiduous and diligent of you. I wasn't aware about those sort of specific things, but I'm in perfect health and I don't really care that much, and I have sort of higher priorities and that sort of thing, and I don't really have a view on any potential future children having vegan diets, for God's sakes. That's a really personal and really patronizing question, but thanks anyway. Do you think animal rights should be based on sentience? Please ask the New Zealand Bill of Rights Act and judicial review questions first. Thank you for your thoughts. Animal rights based on sentience. That's a complicated question, and one that's going to take too long to answer, but if you do want to know the answer to that question, then take my Animals in the Law course next year. Or come and talk to me about it. I'll be happy to have a yarn to you. How did you and your wife, Jessie, meet? See what you did there? That's interesting. We met at a debating tournament in 2002. Yep, that's how interesting we are. What do you think of the Opportunities Party and furthermore their proposal to reinstate an upper house in New Zealand? I think they're an interesting movement. I think that they're an amazing amount of traction. I find their proposal for upper house interesting. I think it's worthy of consideration. It certainly would slow down a lot of this legislation that gets passed far too quickly in our unicameral system, and might be an easy way of providing a break on the executive-dominated parliament we've got at the moment. Yeah, worthy of consideration. Is it true you can get away with doing no readings for your section? Nope. Okay. Do you prefer Geoffrey Palmer's crushed dreams of how New Zealand Bill of Rights Act should function or the current one? If neither, would you personally have the New Zealand Bill of Rights? How would you personally have the Bill of Rights Act apply? That's a good question. I think the current one's the worst of both worlds, right? You either have one or you don't. And you certainly don't have our system, which has got this really complicated and contradictory system of sections 4, 5, and 6 not working together. Honestly, the Brits and their Human Rights Act 1998 is a much cleaner version of ours. I don't really have a problem with our Bill of Rights Act, to be honest. A lot of people do. A lot of people want it more entrenched. A lot of people want it repealed. I think it's done fairly okay by New Zealand, but it could be cleaner and better written, and you could look to the UK for that. In an exam, what are the 4 steps? Like amenability to review, then what? Cook says to read down prohibitive clauses. Are they good law or not? How do we address the standing on test? Sorry, I should be in a judicial review pile. I think I've covered everything. There are no steps. There are no clear cookie cutter ways of doing it. Well, there are, but you follow them at your peril. Prohibitive clauses, you can understand them as simply not being literally applicable. The courts can get around them. And standing only needs to be addressed if it's going to be controversial. Yeah. The draft New Zealand Bill of Rights Act had a section on the Treaty of Waitangi. Why didn't this make it into the final act and where did it go? That's an interesting story, actually. That was actually Māori that said that, no, you can't just on our, basically take the treaty, which we're part of, and just put it into the Bill of Rights Act and put it into legislation without our proper consultational consent. So I think it was, I had to sort of go back to the history on this, but I'm fairly certain that it was opposition from Māori at that point, because the problem about sticking it into legislation, even if it was entrenched supreme legislation, is that you take something that wasn't, it couldn't be amended because it wasn't legislation, and you make it legislatively based, and that really puts it at risk of being done away with. Even though that would make it difficult, it actually makes it possible, whereas the status quo was that it wouldn't be. So that's my understanding of where it goes. So yeah, I think that was a little bit of Palmer thinking this is the right thing to do, but without much consultation with Māori, which was pretty key. Okay, here we go. What gets you off more? 1, judicial review. 2, a draw on the mooting competition. Definitely not that. Running your hand through your hair during a lecture. Or declarations of inconsistency, or your boyfriend. Ah, right, this is when I was referring to the just lovely tinge of homophobia that goes through these questions. That's fantastic. I guess judicial review. What do you do in your spare time? I don't have it. There we go. What do I do in spare time? I brew beer. I run. I watch films. Read books. Do people have hobbies anymore? I don't know. What is a book you have read which impacted your life? Hold up. Animal Liberation by Peter Singer. A pretty influential book. Want to know more about it? Let me know. Hi Marcelo, you picked me literally 8 times to answer your questions. Why? God bless. Because I've got it in for you. Or that was just poor luck, and I'm sorry. If you identify yourself to me, I'll never ask you a question in torts. Yeah, I take torts as well, so, and I ask questions there. So if you come see me, I'll make sure I never ask you a question again. Oh, this one's a good one. Serious question. How can a straight cis man be an effective faculty liaison for LGBT students? What steps do you take? Apologies if this was an incorrect assumption of your identity. Thanks for the potential apologies. It's a good question. I guess my answer would be a more effective liaison than if I wasn't, if that makes sense. We don't have any openly queer staff, and I saw a gap that there needed to be at least someone that queer students could come and talk to and have a friendly, safe space to talk about any issues that they wanted to. And so OUSA runs the system, and there is a rigorous interviewing training process. So it's not simply that I just decided that I wanted to be and that's what I wanted to be and that's fine. I had to go through a process. Look, if I understand that I have limitations, but I've got also a lot of empathy and a lot of understanding, and more than anything else, I just want to provide a friendly ear and a safe space for anyone to talk to, not trying to say that I could ever appropriate or be 100% perfect in this role, but certainly better than not being, because then there probably wouldn't be too many people that questions could talk to or have that safe space, or at least know that they could talk to for certainty. And so I think that's probably that's the only reason I want to sort of to be there and provide that potential avenue. I hope no one was mean. We love you. Thanks. That's no one was too mean, I guess. Okay, 3 more serious questions. How likely is it that the Supreme Court will uphold the Court of Appeal's judgment in Taylor and Attorney General? It's a good question. I don't know the answer. I hope the answer is yes, because this is a slam dunk situation in terms of both the High Court and Court of Appeal providing clear very well-reasoned judgments as to the existence of the jurisdiction of a declaration of inconsistency and also justification for it. But as you know, my views, if you didn't know, then I don't know what you've been doing. The Supreme Court has an uncanny ability to ruin these sorts of things with multiple long, useless judgments that go all over directions and just create a little bit of miasma. Thanks, Marcelo, for teaching. Enjoyed your classes. Okay. What is your opinion on helping New Zealand citizens understand more of their rights before seeking a lawyer and spending money? I think the Community Law Centre process works really well. I'm part of the Community Law Centre here in Dunedin, and I think that's a nice triaging way of determining whether or not they need to see a lawyer and spend money before they actually do so. Free community legal advice, you should definitely become part of it. It's a really, really good program, and I think that if that was better funded and more widespread throughout New Zealand, then that would be an easy fix to that problem. Okay, last serious question. Do you think the entrenchment of the New Zealand Bill of Rights, including the original Treaty of Waitangi section in Geoffrey Palmer's draft, would make a positive difference to treaty relations today, or whether it would make things a whole lot more complicated? We'll never know, because as you'll learn with Andrew, it was only a year after the white paper, Geoffrey Palmer's draft, that a big change happened. I won't spoil the surprise, but other legislation incorporated some treaty principles that started down a particular path. If they had managed to pass the Bill of Rights Act in that form that Geoffrey Palmer wanted it to be passed, then I imagine you would have had a very similar but stronger line of jurisprudence than the one we have today. But I go back to the point that there wasn't a heap of Māori support for the entrenchment of and incorporation of the treaty into the Bill of Rights Act in that form, and so it would have been complicated. I think anything could have been an improvement upon what was going on pre-1985 and pre the bolstering of the Waitangi Tribunal to take into account historical grievances as well as contemporary grievances. But often there is an assumption that legislative inclusion or just recognition of stuff in legislation is the ultimate fix, and race relations in New Zealand requires a whole lot more than simply legislative change to improve. Okay, we have just a few more personal questions. If you're still with me, I am impressed that you've listened this far. Oh, sorry, gosh, I've missed these up. Can we skip discussing locus standi, or do we need to go through it, or can it be addressed by means of an introductory sentence? If you want to talk about standing, but if it's not relevant, you don't need to. That's my final word. Kerry claimed in a public law tutorial that she could beat you in a fight. Would you agree with this statement? Yes, obviously. What's your favourite beverage? Bribes accepted. Ah, now we're talking. I love hoppy beer. American Pale Ale. What's your spirit... Don't bribe me though, please. What's your spirit animal? A sheep, obviously. Okay. Lick my asshole. That's clever. Except it's not a question. Idiot. Did David Bain do it? Well, a jury says no, but then an original jury said yes. Do you know that when you shout, you sound like Seinfeld? Sorry. Oh, that's... I didn't know. Thank you very much. I guess I'm impressed with myself, or maybe I shouldn't be. Okay. 2 more questions. More of a statement, though. You should get your weekend coffee from Salt, not Starfish, or Espy. I've seen you leaving there. Ours is better. That's not creepy in the slightest. And finally, where do you get your haircut? I get my haircut at Blokes, not because I agree with the name, it's gender normativity, but instead because they are cheap and they give me a beer sometimes when it's appropriate. Okay, it's been an absolute pleasure teaching you for the last few weeks, both this semester and last. You don't need to worry about the test on Tuesday. I know you will be, and I don't know how many times I'll be able to say this without you not getting worried, and it's probably just stressing you out more even thinking about it. But as long as you breathe, as long as you trust your instincts, and as long as you take it slowly, you will be absolutely fine. Not trying to trick you. Don't try and find some sort of secret formula or key to unlock the question. That's not the way it works, right? It's simply taking a step back, understanding the context, answering the questions that have been asked. Yeah, you'll be absolutely fine. Absolute pleasure teaching you. You've been an absolutely magical class, actually one of the best second years that I can remember in a long, long time. And I wish you all the very best for the end of the year. Take care of yourselves. It's only going to get a little bit more stressful from here on in. And if you need any more assistance with regards to judicial review or anything else in the second year program, then you'll find my door open and my email inbox waiting. Okay, thanks very much. Marcelo out.